The first challenge is to decide if a court has jurisdiction to hear a case. So in determining whether the courts in Malaysia have jurisdiction in hearing a civil proceeding, reference must first be made to Section 23, subsection 1 of the Courts of Judicature Act 1964, which provides several situations. The cause of action arose, the defendant or one of the several defendants reside or has his place of business, facts on which the proceedings are based exist or alleged to have happened, or the location of the disputed land must all be in Malaysia. Section 24 of the same Act provides for more specific situations where the Malaysian High Court has civil jurisdiction. The case of Bank Bumiputra Berhad and International Teen Council explains that generally the jurisdiction of courts over person is territorial. Situations which allow the local courts to exercise extraterritorial jurisdiction are now provided under Order 11, Rule 1 of the Rules of Court 2012, where notice of writ outside jurisdiction is allowed. So under Order 11, Rule 1, Para C and F, there must be physical presence of the non-resident defendants or place of the business of the contracting party is in Malaysia. This is also mentioned in United Malayan Banking Corporation Berhad and Su Lian Toy, where local courts are given extraterritorial jurisdiction where one of the defendants resides or has business in Malaysia. So what are the challenges particularly? So number one, in Malaysia, territorial borders are still the basic factor for determining jurisdiction of the courts. So the principle is very rigid and limited. Malaysian courts only have jurisdiction when the matter involved in the dispute is in Malaysia. There must be physical presence. Furthermore, Malaysian courts also face some challenges in cases involving e-commerce contracts entered via the internet, because the internet can be seen as borderless and very fluid when a trader in most circumstances is not identifiable, or the location of the trader and the website accessed by a consumer can be in two different locations. Secondly, generally in Malaysia, applying Order 11, Rule 1 of the Rules of Court 2012, the courts in Malaysia can only assume jurisdiction if the person is domiciled in Malaysia, or carrying on business in Malaysia, or conduct a contract in Malaysia. Thirdly, in an extraterritorial dispute, a party in Malaysia can also be at risk of bringing a suit in the court of another country as imposed in the contract, or even exposure to enormous legal costs and legal liability.
After determining which court had jurisdiction to hear a proceeding, the next challenge for the court is to decide which choice of law should be used in the dispute between the parties. For the purpose of choice of law in a contract, the English common law will be used, since the Contract Act 1950 does not provide any rules in determining the choice of law. There are three factors that will be considered by the court for applying the appropriate choice of law. First, the courts will enforce the parties' express choice of law. If there is no express choice of law, then the court will look into the intention of the contracting parties. Or, if the court cannot determine the choice of law because there are no express provision or it cannot be implied, then the courts will determine objectively the system of law which has the closest and most real connection to the transaction. Basically, these tests rely on the basis of what the contracting parties had expressly stated or inferred from the conduct or intention of the parties. However, the difficulty arises when the court applies straight from first to the third stage, because it is difficult to differentiate the second and third tests, as they often merge into each other. Hence, it is important for the parties to expressly state which law to adjudicate their contract, as this express provision will be prioritized first to determine which court can hear the case.
The third challenge is to decide whether the court can enforce a foreign judgment in the case. In Malaysia, foreign judgments may be enforced without the need to commence a fresh action. The Reciprocal Enforcement of Judgments Act 1958, REJA, is a specific statute enacted to provide the mechanism for how such judgments can be enforced in Malaysia. The reciprocating countries are United Kingdom, Hong Kong, Singapore, New Zealand, Sri Lanka, India, and Brunei Darussalam. Section 3, Subsection 3 of REJA 1958 lays down the following criteria for a foreign judgment to be registered, and those are: first, judgment must be final between parties; second, judgment must provide for a sum of money to be payable excluding taxes, fines, or any form of penalty; and third, judgment was pronounced by a court from one of the reciprocating countries set out above. However, enforcement is only limited to reciprocating countries. Hence, for countries which are not included under RIJA, plaintiff needs to either file a new suit or obtain a summary judgment, which is the procedure set forth in Order Draft of Rules of High Court to enforce a monetary judgment.
In conclusion, firstly, jurisdiction is still territorial based, and thus if a person wants to bring a suit under Malaysian laws, they must be a resident of Malaysia or the matter in dispute is in Malaysia. Secondly, the court will then consider three factors, and the most important one is for the parties to state their express choice of law in the contract to avoid any complications. And lastly, enforcement of the judgment is limited to countries under RIJA, and if not, the plaintiff must either file a new suit or obtain a summary judgment. That's all from us. Thank you and have a good day.